Hello, YouTube. I'm Vince White. I'm an employment attorney, still somehow an employment attorney. And we are answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. I believe this video will be going live the day after Christmas, so I'm still wearing my very festive hat. And we have a question here from YouTube user Ruben. Great name, Ruben. The question reads as so. Amazing videos. I appreciate all the awesome knowledge you are sharing. Happy to do it. I'm glad it helps. I'm wondering if you can answer one question for me. I sure hope I can. If I can't, my whole career is a lie. I'm about to hire an attorney, but have done most of the work so far on my own and recently filed with the EEOC. And a week later, I received an email that states, your charge has been identified as appropriate for early mediation. The letter goes on to tell me about how successful the National Mediation Program is. Does this letter mean they skipped the investigation or that they saw the evidence submitted and decided there is probable cause for discrimination? I was expecting to wait months and it seems it was fast-tracked. Hey, I'm really glad to hear that your local EEOC office is moving things along really quickly. The fact that they are offering you mediation does not mean that investigation was skipped. It just means that they are trying to get people to mediate cases. So they're sending letters out to you and to your employer saying, hey, would you both like to mediate? And if you both say yes, they will schedule a mediation. They do this because it is a really good way to move cases along. A lot of cases do settle at mediation. Even cases that don't settle at mediation can benefit from mediation because it can cause a settlement later on. Right? Everyone's sitting down and having a conversation about what they actually want in terms of getting this done can be really valuable even if it doesn't happen that day. So listen, that's a great program. They're not wrong. The EEOC mediation program is stellar, even though some of their mediators are highly questionable in terms of training and capabilities. It doesn't really matter. Right. And let me stress, I know an amazing EEOC mediator. Deborah Reich is the sun, the moon, the stars. She is the sun rising in the east and fixing problems, settling cases all day. And I say this without a hint of irony or joke. She's wonderful. But I've also sat with EEOC mediators that I didn't think could really tie their shoes. And it was largely irrelevant because, you know, they're like, they're kind of barking at the parties. And you're like, oh, no. Child. No. You don't matter. We're going to do this. Defense counsel, plaintiff's counsel, we're going to sit down and have a conversation about what is and is not on the table. Our clients will make informed decisions because one's a large company and the other is a sophisticated, intelligent human being who knows what she or he might want, right? And so the mediator can be like, that's not how it's going to be. And again, that's enough out of you. Even the worst mediator can be put in a corner and given crayons, and you can go and have an actual mediation and make progress. And progress happens even if you don't settle, right? Just having someone coming to a certain dollar point, right? Like if you're asking, just for hypothetical, you're asking for 500,000, they say, well, no, but we would give you 60,000. That's valuable to hear. Not because you need to change your mind necessarily, but because they came to 60,000. So you know quite a bit from that. They've signaled that your case does appear viable to them. That is way more than nuisance value. They are trying to pay you because they think bad things could come for them out of this case, right? You've learned a great deal. Also, the next time you negotiate, they might be like, hey, we're offering you 40. Be like, well, why? You were at 60 before and nothing's changed, so why would you go down? They're not required to stay at 60. But human nature does kind of make it difficult for them to go down from 60, right? Like it's tough for them to revisit things and go down. There's people who do, and often those people are diabolical in some way, right? But it's rare. I would say it's, less than 5% of cases are you going to see people who make an offer and then later try to go back on the offer or drop the offer later if something didn't happen to worsen the plaintiff's position. Anyways, I think I'm rambling a little bit. I really hope this was helpful. Like and subscribe. It does help me to help more folks just like you.